Good day, everyone. I'm JDP ABRASALDA from PCBET 01401A. Today, I am assigned to report about the Section 1 and 2 of the revised Corporation Code of the Philippines. The governing law in corporation was the Batas Pambansa Bilang 68 or BP 68. This was also known as the Corporation Code of the Philippines. Very recently, a new law amending the old Corporation Code, and this is the Republic Act number 11232, which is also known as the Revised Corporation Code of the Philippines. Title 1: General Provisions, Definitions, and Classifications. Section 1, Title of the Code. This code shall be known as the Revised Corporation Code of the Philippines. The Revised Corporation Code of the Philippines was approved by Congress on February 20, 2019. It was signed into law on February 21, 2019 and took effect on February 23, 2019. Before the Corporation Code of the Philippines revised, it was repealed as Batas Pambansa Bilang 68 or the Corporation Code of the Philippines 1980. It means that the Batas Pambansa Bilang 68 or the Corporation Code of 1980 was officially no longer valid. What are the reasons of revising the Corporation Code? Number 1. Promotes ease of doing business. It aims to further ease the formation of corporation and filing of applications and report, which have frustrated those who deal with the bureaucracy. Number 2. Strengthening the powers of the Securities and Exchange Commission. It empowers the Securities and Exchange Commission to fully enforce the new law. And number 3, adopts the new technology. It is also introduced new rules that align with the developments in technology and new laws that came after the old Corporation Code or the BP 68. Section 2, Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attribute, and properties expressly authorized by law or incidental to its existence. Section 2 is a statutory definition of a corporation. It refers only to a private corporation or to a corporation corporation organized under the Corporation Code. It only means that there are other types of corporation and they also have their own given definition. In the definition itself, we can clearly identify the characteristic of the corporation by mere reading of the given definition as provided under the Section 2 of the Revised Corporation Code. So what are the characteristics of a corporation? Number 1, it is an artificial being. Capacity to contract and transact business. In the eye of the law, there are two types of person. We have number 1, the natural person, and number 2, the artificial person. When we say natural person, tayo yan, yung mga tao, or the human being, and artificial being or artificial person is the businesses. When we say that the corporation is an artificial being, a corporation is just like a human person. The law creates the corporation as an artificial being because the law gives the corporation its own personality. Although um, it cannot exist as a natural being, so it has its own personality that's separate and distinct from the persons composing it. Um, the corporation can be sued by someone, but not, but not suing the owners directly. Again, the corporation only exists in the eye of the law. It exists in the legal fiction only. Number 2, created by the operation of law. Creature of the law. It is created by the operation of law, unlike the partnership which created by the agreement of the partners or meeting of minds na tinatawag. A corporation is not created by the agreement of the stockholders, but it is created by the reasons of the law. Only the law creates the corporation. When we say law, it is the BP 68 and now the revised corporation code of the Philippines. Only the state through the Securities and Exchange Commission can grant a business license to operate as a corporation. May mga formalities kasi na pinagdadaanan para maka-create ng corporation. Number 3, it has the right of succession. Strong juridical personality. A corporation continues to exist for a period for which it has been formed regardless of the changes of the ownership. It means that the corporation has the continuity or pagpapatuloy. So, yung death or incapacity ng mga stockholders does not dissolve the corporation because it has the characteristic of the right of succession. And number 4, it has the power, attributes, and properties expressly authorized by law or incidental to its existence, a creature of limited power. Because a corporation is an artificial being, only the powers, attributes, and properties granted to it by the law can be exercised. Kumbaga, yung mga kaya lang gawin ng corporation ay yung kung ano yung sinabi ng batas or kung ano yung nakasulat sa Revised Corporation Code of the Philippines. So, question, is Boys Code of the Philippines a private corporation? Ang sagot ay hindi. Dahil ang Boys Code of the Philippines ay isang public corporation. Kaya siya naging public corporation dahil kinreate ito para sa public interest or purposes. So, yung Boy Scout of the Philippines ay hindi subject to the test ng government ownership or control and economic viability. And yung Boy Scout of the Philippines din ay isang instrumentality ng ating national government. Next topic ay government-owned or controlled corporation or GOCC. GOCC refers to any agency organized as a stock or non-stock corporation vested with functions relating to public needs, whether governmental or proprietary in nature, and owned by the government directly or through its instrumentalities, either wholly or were applicable as in the case of stock corporations, to the extent of at least 51% of its capital stock. Okay, government-owned or controlled corporation. From the title itself, corporation ito na pagmamay-ari ng government. These corporations created under the special law or charter. They are treated as a private corporation and not as a public corporation. Para malaman natin na whether a corporation is a government-owned or controlled corporation, kinakailangan na yung shares of stock ng the government must be at least 51% or 51% shares of the capital stock. Masasabi na ba natin na hindi porket government-owned or controlled corporation siya, wala na siyang stock? Siyempre, sagot dyan ay meron. Pwede siyang stock or non-stock. Pero kung stock siya, kailangan present yung dalawang requisites para maklasify siya as a stock corporation. Number 1, yung capital stock ng government-owned or controlled corporation ay divided into shares. At yung pangalawang requisites naman ay yung authorized siya para i-distribute yung dividends and allotments of surplus. Then yung profits dun sa mga stockholders. So kapag may missing dun sa dalawang requisites na yon, hindi siya matatawag na stock corporation. At kapag non-stock corporation naman, ang kailangan lang ay members, tapos yung income nila ay hindi dinidistribute sa mga stockholders, hindi dinidistribute ng mga stockholders sa members. Again, para matawag na government-owned or controlled corporation, kailangan ang government ay directly or indirectly owns or control 51% share of capital stock. Yung example nito ay yung example ng government-owned or controlled corporation are the Land Bank of the Philippines, Lang Center of the Philippines, and the National Food Authority, and many more. Piercing the veil of corporate fiction. In other terms ay instrumentality or alter ego. It is basic in corporation law that a corporation with a legal personality separate and distinct from those acting for and its behalf, and in general from the people comprising it. Sinabi ko nga kanina na ang corporation ay may sariling personality na hiwalay sa mga stockholders. Therefore, ang liability ng corporation ay hindi liability ng stockholders dahil nga separate yung juridical personality nila. When we say piercing the corporate veil, the court disregarding the separate personality of a corporation from its member. So if the corporation's separate personality is used as a cloak or as a mere scheme for fraud or illegality, then the court will pierce the corporate veil. Again, yung kapag ginamit lang ng corporations yung separate personality nila as a butas dun sa ginawa nilang kasalanan, dun papasok yung piercing the corporate veil. Ibig sabihin, i-disregard na yung separate corporate personality. Again, doctrine ito na maaaring managot ang corporation sa ilalim ng batas at mapawalang bisa yung separate and juridical personality nito. For example, yung ABC Corporation ay may sariling pagkatao kumpara dun sa stockholders or si individual A, individual B, at individual C na nag-incorporate or bumuo dun sa corporation. Tapos, nagsampa ako ng kaso dun sa ABC Corporation at biglang nag-dissolve. At the same time, nanalo ako dun sa kaso. So, yung parang nangyari is, nanalo ako sa kaso pero parang walang nangyayari dun sa obligation, sa naiwan na obligation ni ABC Corporation. Then, surprisingly, nagkaroon ng DEF Corporation. At nalaman ko rin na yung DEF Corporation ay same lang yung identity ng directors at officers, pati yung manners ng pag-keep ng corporate books and records, tsaka yung methods ng pagkandak ng businesses dun sa ABC Corporation. So in other words ay nagpalit lang ng pangalan yung ABC Corporation into a DEF Corporation. At dito na ngayon papasok yung doctrine of piercing the corporate veil. Bakit? Yung doctrine na to yung magtutusok dun sa belo ng juridical personality ng dalawang corporation. So ibig sabihin magiging lagusan yung doctrine of piercing the corporate veil para dun sa juridical personality ng dalawang corporation, para gawing liable si DEF Corporation dun sa obligation ni ABC Corporation, dahil halatang-halata na tinakasan ni ABC Corporation yung obligasyon niya. Next naman ay yung factors for the application. Number 1, stock ownership by one or common ownership by both corporation. Number 2, identify of directors and officers. Number 3, the manner of keeping corporate book and records. And number 4, methods of conducting businesses or business. Elements of corporate veil. Number 1, control. Not mere stock control, but complete domination, not only of finances, but of policy and business practice in respect to the transaction attack must have been such that the corporate entity as to this transaction had at the time no separate mind, will, or existence of its own. Okay. The first element is the instrumentality or control test. This test requires that the subsidiary be completely under the control and domination of the parent corporation. It examines the parent corporation's relationship with the subsidiary. It inquires whether a subsidiary corporation is so organized and controlled and its affairs are so conducted as to make it a mere instrumentality or agent of the parent corporation, such that its separate existence as a distinct corporate entity will be ignored. It seeks to establish whether the subsidiary corporation has no autonomy or the parent corporation, though acting through the subsidiary in form and appearance, is operating the business directly for itself. Number 2, such control must have been used for the defendant to commit a fraud or wrong, to perpetuate the violation of the statutory or other positive legal duty, or a dishonest and an unjust act in contravention of plaintiff's legal right. The second element is the fraud test. This test requires that the parent corporations conduct in using the subsidiary corporation be unjust, fraudulent, or a wrongful act. It examines the relationship of the plaintiff to the corporation. It recognizes the piercing is appropriate only if the parent corporation uses the subsidiary in a way that harms the plaintiff's creditor. As such, it requires a showing of an element or injustice or fundamental unfairness. Number 3, the said control and breach of duty must have proximately caused the injury or unjust loss complained of. The third element and the last element is the harm test. This test requires the plaintiff to show that the defendant's control exerted in a fraudulent, illegal, or otherwise unfair manner toward it, cause the harm suffered. A causal connection between the fraudulent conduct committed through the instrumentality of the subsidiary and the injury suffered or damage incurred by the plaintiff should be established. The plaintiff must prove that unless the corporate veil is pierced, it will be it will have been treated unjustly by the defendant's exercise of control or and improper use of the corporate form, and thereby suffer damages. Um, to summarize, piercing the corporate veil based on the alter ego theory requires the three elements: the control of the corporation by the stockholders or parent corporation, the fundamental unfairness imposed on the plaintiff, and the harm or damage caused by the plaintiff by the fraudulent or unfair act of the corporation. The absence of any of these elements prevents piercing the corporate veil. Succession or artificial succession. So, ibig sabihin lang nito ay yung pag-continue na existence ng corporation ay hindi. Remember, hindi naapektuhan yung changes sa member or stockholders or kahit sa pag-transfer pa ng shares ng mga stockholders to a third person. Hindi kagaya ng partnership na pwedeng ma-dissolve by operation of law kapag nagkaroon ng death or incapacity yung partners. Again, hindi maapektuhan yung changes sa members or stockholders or kahit sa pag-transfer pa ng mga stockholders to a third person. Next ay yung powers of a corporation. A corporation has not power except those expressly conferred on it by the corporation code or special law, and those that are implied or incidental to its existence. In turn, a corporation exercises said powers through its board of directors and or its duly organized authorized operation in agents. Ang corporation daw ay walang powers except dun sa tatlong nabanggit, which are the 1. The express power, 2. Implied or incidental power, and 3. Yung powers through board of directors, and I will discuss it one by one. Una ay yung express power. So, ito yung corporate power na binanggit or nakasulat sa batas. At ang batas na tinitignan natin when it comes to a private corporations ay yung yung corporation code or the revised corporation code. At ang express power na yan ay divided pa siya into two. We have the general power at specific power. Pangalawa, meron tayong incidental power or inherent power. Ito naman yung mga powers na may reasons yung pagiging corporation niya mismo. Pwede niyang ma-exercise yung power na ito. Ito kasi kahit hindi ito sa batas, kahit wala ito sa batas, pwede pa rin. May mga certain rights ang corporation na kahit hindi nakasulat sa batas or kahit anong batas na related sa corporation ay pwedeng ma-exercise dahil inherent siya or nandun na yun sa corporation na yun. At yung isa naman ay yung implied or necessary power. Ito naman yung corporate power na by reason of express power naging necessary siya or naging implied siya. Naging necessary siya para magawa yung express power. Para same lang din dun sa inherent power. And 3, yung a corporation exercise its power through its board of directors or trustees, or its duly authorized officers and agents. That will be all. Thank you.